A seller may sell land today, but still be entitled to more monies years later. That is the purpose of an overage agreement. In this video, we'll break down what overage is, why it is used, how it operates, the main types, and how it is usually protected. So what is an overage? An overage, sometimes called clawback, is an agreement requiring the buyer to pay the seller extra money if the land increases in value after completion. It is commonly used where land has future development potential. For example, a seller sells land at today's value, but later the buyer gets planning permission. The land then becomes more valuable, and then the seller receives a share of the uplift. So why is an overage used? An overage is used to balance risk. For sellers, it protects against selling too cheaply before future value is unlocked. For buyers, it allows them to buy now without paying full development value upfront. It is especially common where planning permission, redevelopment, change of use, or future sale is uncertain. So how do they operate? An overage agreement usually sets out the following: the trigger event, the payment formula, the overage period, who must pay, when the payment is due, and how disputes are resolved. The formula may be based on a percentage of uplift in value, sale proceeds, development profit, or enhanced land value. The agreement must be drafted carefully because small wording differences can completely change the commercial outcome. So let's have a look at the types of overage. Number one, planning overage. This is triggered when planning permission is granted. It is one of the most common forms. Number two, implementation overage. This is triggered when planning permission is actually implemented, for example, when development starts. Number three, disposal overage. This is triggered when the buyer sells the land or sells part of it at a profit. Number four, development overage. This is linked to construction or completion of a development, often based on units built or sales achieved. Number five, change of use overage. This applies where land becomes more valuable because permitted use changes. Number six, sales or profit overage. This is calculated by reference to the actual sale proceeds or development profit. So now let's have a look at trigger events. The common triggers include grant of planning permission, implementation of planning permission, sale or transfer of the land, start or completion of development, change of use, or occupation or sale of completed units. The seller usually wants an early trigger such as grant or planning permission, but the buyer usually prefers a later trigger such as a sale or implementation because cash may not be available earlier. So how are overages protected? A common method is restriction on the title at HM Land Registry. A common form is consent restriction, similar to Form N, such as no disposition of the registered estate by the proprietor is to be registered without the written consent signed by the beneficiary of the overage or the conveyancer. Sometimes a certificate restriction is used instead, where a conveyancer certifies that overage provisions have been complied with or do not apply. Overage may also be secured by way of legal or equitable charge, and HM Land Registry recognizes that overage agreements may be secured in this way. So overage agreements are powerful, but they're also technical. The trigger formula, duration, and protection mechanism must also be clear, because if the drafting is wrong, the seller may lose future value or the buyer may take on unexpected liability. If you enjoyed this video, I'd be grateful if you could please like, comment, and subscribe to Legal Development Limited for more. Thank you.